to State versus Damu Alston. Can we please have appearances of counsel?
Deborah Sims, Acting Assistant Prosecutor, Special Deputy Attorney General, appearing on behalf.
Good morning, Your Honor. Daniel Bornstein, Deputy Attorney General, on behalf of the Attorney General.
Good morning, counsel. Please be seated. Mr. McMahon.
Thank you very much. If I may request 3 minutes for rebuttal at this time.
That's fine.
Mr. Chief Justice, members of this honorable court, if it pleases this court, I feel like I'm signing my life away. Should I not have a lawyer in here with me? With those words, Damu Alston expressed a desire for counsel, a plea for help, a specific type of help of counsel. He recognized that he needed this help dealing with the magnitude of his situation, that he alone was outmanned by law enforcement. He was in a custodial situation. He had 2 detectives in front of him. He had been charged with as serious a crime as exists in our state. In New Jersey, the prosecution bears a heavy burden of proof in demonstrating that a defendant has waived his right against self-incrimination. Proof here in our state beyond a reasonable doubt. New Jersey affords greater protections under our right against self-incrimination than is provided by the federal Constitution. And in State v. Reed, this court took the time to spell out exactly why we feel the way we do. And it made clear that how we view the right of counsel as guaranteed when we talk about our Miranda warnings being given. The right of counsel during police interrogation is a preventative measure that protects an accused from self-incrimination during police questioning, Reed said. The essential purpose of the right of counsel, of the right to counsel, in the context of a custodial interrogation is to prevent self-incrimination. Again, quoting from Reed, the atmosphere of custodial interrogation is inherently coercive, and protecting the right against self-incrimination entails counteracting that coercion. The right of self-incrimination is a core right. We view it as a core right that's preserved and defined by ancillary rights, those being the right to silence and what we're talking about here, the right to counsel. These ancillary rights are imperative. They are given greater protection under our state law because we find them essential to preserving the right against self-incrimination. Now, Reed says, and this is at the core of I think where we are going to be today, that a suspect need not be articulate, clear, or explicit in requesting counsel. Any indication of a desire for counsel, however ambiguous, will trigger entitlement to counsel, will trigger the entitlement to counsel the same as a clear request would have done. No difference. And that is, as the Attorney General goes through in his excellent brief, does a great job at showing us the difference between the United States Supreme Court in the Davis case and this court in Reed. In Davis, the United States Supreme Court recognizes that defendants, some might be very articulate, some might be clear, some might be able to express themselves in a way that we would find refreshing and easy to do. Others will not. They quite clearly may be saying the same thing. They may want the same thing. They just might not be as good at expressing what they want. Davis says we are going to be aware of that, but I don't want to say they don't care, but they say unless you're clear, an ambiguous request for counsel can be disregarded. There's no requirement to do anything. It would be completely disregarded. In Reed, what this court said is an ambiguous request, or however you want to rephrase it, if it's a request for counsel, it will be given the same effect as a clear request for counsel, which means, and I think the heart of where some of the arguments are, which means all questioning must cease, that an ambiguous request for counseling must put an end to all questioning by the police. That is,
are you saying there can be no clarification?
That is what I'm saying, Justice Alban. And I recognize the difficulty with, well, I'm not going to say the difficulty with my argument, because I think my argument is clear, and I think it is what Reed set forth, and I think it's what many of the appellate courts have followed since Reed. But in Chu, this court seemed to endorse a situation where an ambiguous request for counsel could be followed up with clarification questions. And that's the only area.
You know what's problematic about that?
Yes.
If the police officer doesn't understand what on earth the person is saying, are you saying that's the moment he has to stop? That in itself constitutes ambiguity?
Well, I would say that.
And
to not understand anything what the person's saying, I don't think could ever be.
Why don't we go through I think what will be effective is if you go through the dialogue between Detective Smith, Detective Muhammad, and Alston, and try to make your point, your case.
Yes, Justice Alban, I would be happy to do that. Thank you. The dialogue begins.
I feel like I'm signing my life away. What does that mean?
Well, and I assume the courts listen to it as well. I mean, it's as he's signing the waiver, it's an expression in his mind that I feel like I'm signing my life away. I think that's pretty clear. I feel like.
Are you arguing that is an assertion of the right to counsel?
No,
or?
I'm not.
Okay.
I'm not. Okay. Detective Muhammad then interjects. Not signing your life away. And all these things are said almost simultaneously.
Okay, let's stop there.
Yes.
Was that appropriate or inappropriate?
Well, I would argue to the court it's inappropriate. I think that the case law allows some misleading statements to be made by detectives. I think in the context.
Well, not misleading when it comes to advising a person of his or her rights.
Yes, I agree. And that's what I was going to say. In the context of everything that's said here, I think that is a big problem. When we look at the context of all that's said, yes.
What should he, instead of saying not signing your life away, what do you suggest he should have responded?
He could have remained silent. He could have remained silent to that, or he could have asked them to read the waiver again. He could have done either of those two things, either of which would be preferable to basically misleading the defendant, because clearly he was signing his life away.
If Justice Alban doesn't mind, before you go on to the next line.
Yes.
Is the issue before us truly a legal issue? Are there any factual issues involved in the issue before us?
I don't believe so, Justice Stern. Initially, and I think the court might have gotten a glimpse of this, there were some issues with regard to the transcription of the tape.
And they were corrected.
After long periods of time listening by all parties, yes.
So in responding to Justice Alban's question, we're dealing with a legal issue where there's no deference to either court that has decided the question.
No deference to the
legal conclusions.
Is this a de novo review? Because we can look at the dialogue just as well as the lower court.
I would
say
yes. I would say yes to that question.
So please proceed. I'm sorry.
Mr. Alston then says, should I not have a lawyer in here with me? And that's follow. And
your position is that should have been the end of the matter.
Yes.
It was inappropriate for the detective to respond you want a lawyer? Answer no.
Yes, Justice Rabner, my first position is, yes, that is a statement requesting an attorney. I know that in the transcript we put a question mark on it. Maybe that would be the only, difference, whether you interpret it as a question or as a statement. It's subject to both interpretations, clearly. But that alone is a clear request for an attorney that the defense position is everything should end. We don't even need to.
Should I not have a lawyer in here with me? He's not requesting. Are you saying it would have been inappropriate for the detective to re-advise some of his Miranda rights? I repeat again to you, you have a right to counsel. Before questioning, if you cannot afford counsel, one will be appointed for you. Are you suggesting that would have been inappropriate?
I am, Justice Alban, and if I could, I am. If we look at the statement, which even the Attorney General agrees is a clear request for counsel, maybe I should have an attorney, or maybe I should have a lawyer. From the Wright case, quoting Maglio versus Jago. In that situation, if we're going to afford that, a clear request for counsel, I feel hard-pressed to say any argument that should I not have a lawyer in here with me is also a clear request for counsel. But I'm prepared to move beyond that, Justice Alban, and say that even if it was viewed as an ambiguous request for counsel, since Reed says an ambiguous request for counsel should be treated the same as a clear request, that is that an ambiguous request for counsel triggers, and that's the language used by Reed, will trigger entitlement to counsel, that everything has to stop. This court would not allow a detective, after someone said, I want a lawyer in here, I want a lawyer, to say to that person, are you saying you want a lawyer? And then the person said, and then if the person said no, you would say you weren't allowed to ask that question. We were not allowed to breach that answer that was given by the defendant. And I'm saying the same application should be given here. And to continue, Justice Alban, in the event that we go beyond, the detective Muhammad says you want a lawyer, and that's when Alston says, no, I'm asking you guys, man, I see you guys, man. I'm sure the court's listened to it and heard it in the context that he gives it. Detective Muhammad says, again, all these things are happening together. I can't make you. And Mr. Alston says, sir, if I did want a lawyer in here with me, how would I be able to get one in here with me? That's when Muhammad responds, that's on you. If you want a lawyer, then we stop, and you going to get your lawyer. And I'm going to stop there, Justice. I know there's more to his response, but if I may, that's on you. If you want a lawyer, we stop, and you going to get your lawyer. That only tells half of what the defendant was entitled to hear. And Judge Vasquez, and this might be one area, Justice Stern, where I don't know that it's binding on this court, but it certainly, I would say, should be of interest to this court, that a neutral judge, Judge Vasquez, hearing this, feels that it is certainly susceptible to the interpretation that the responsibility for getting a lawyer is on Alston. And not just Judge Vasquez, but if we look at the transcript it was Detective Smith who testified at the hearing. When Detective Smith is asked what Detective Muhammad meant by that statement, at page 47 of his testimony, at line 2, he begins, I don't know what Detective Muhammad was referring to. If he was saying that's on you, in other words, he has to go and make a phone call to get his lawyer, or if he was inferring that it was that was it was his choice whether or not to stop the questioning and go get a lawyer. His own partner believed that it was equally susceptible that the responsibility was on Alston to make the call and to get his lawyer. And if I could back up a moment, Justice Alston, why I believe that...
Well, stop for one moment.
I'm sorry.
Whose responsibility is it then? It's not to trigger the Sixth Amendment right and to carry forward, because it's a person's individual right to have counsel. You can have counsel of your choosing. If you cannot afford one, one will be appointed for you. But they don't. The system doesn't know that you can't afford one until you affirmatively come forward and say, I want a lawyer, but I can't afford one. In that context, why is it incorrect for Detective Muhammad to have said, this is on you? You got to get this ball rolling. You get it rolling, but if you start the ball rolling, we stop. We don't ask any more questions. All of which is a vernacular transition, or translation, frankly, of what Miranda says.
Justice Rivera, so if this Court were and to move beyond and to say that clarification questions were allowed, if this Court were to go to that level, then my response to you would be as follows. Detective Muhammad had an obligation at that point in answering that question to, at minimum, restate his Miranda rights clearly and both sides of it, so that he understood, sure, if he wanted a lawyer and had a lawyer, he could call that lawyer and he would have the opportunity to speak to that lawyer or get that lawyer, however. Or if he could not afford an attorney, that one would be appointed to him at no expense to himself. He needed to be advised of both sides of that.
But hadn't he just been told that? And more importantly, he had it in front of him in writing, because he had the waiver in front of him in writing that says that.
If I could, I don't know where the waiver was at the time this was going on. It's not a video statement. It's an audio statement. Even if it was right in front of him, the chances that he would be looking at it.
Well, let me just clarify that for you, since you seem to be a tad confused on the facts. If you look at the settled transcript of the interrogation,
yes,
it starts out with Detective Smith saying 10:20, correct?
Yes.
And Detective Muhammad saying 10:20 a.m.
Yes.
If you look at the signed waiver says it was signed at 10:20 a.m. Sound pretty?
I'm willing to.
And it's at that point that Mr. Alston says, I feel like I'm signing my life away. Signing the waiver.
Justice, I'm willing to accept that waiver might have been right in front of him.
Okay.
I'm willing to accept that. But given all that was going on, and I think a fair listening to what was going on, he wasn't reading from that form at that point. It was in his vicinity, clearly. But it
had been read to him, had it not?
It had. I do not dispute that.
Okay.
I do not dispute that.
I'm sorry.
I'm sorry, Justice.
Oh, I interrupted. I'm sorry.
I was just going to say I do not dispute that. I would just cite the State versus Pilar, which basically says you can't tell somebody his rights one way in one breath and then say it differently in the next moment and expect that he's going to put those two things together. He was told two different things, or at least he was told one complete thing and then only one partial. And I don't want to be repetitious, but even Judge Vasquez and Smith, the detective's partner, both thought it would be susceptible to that interpretation. Yes, Justice.
This is a 2007 murder case. So in a murder case, by then, everything had to be recorded.
That is absolutely correct.
Is there a recordation of what happened before this particular exchange?
Yes, there's a recording of the entire Miranda rights being read to him by Detective Smith was the one who you first hear on the tape, and he reads him all his rights. Detective Muhammad does not interject himself into this process until Damu Alston says, I feel like I'm signing my life away. And that's when Muhammad takes over. But yes, it's all recorded.
Okay, I'm sorry, I did not have that.
Yes, Justice Lebecki.
Detective Smith, right around the same vicinity of the transcript that you were citing before, indicated that he viewed the defendant's questions as an attempt to seek clarification of his right. So is it your position that when the defendant is asking questions that the detectives perceive as seeking clarification, that clarification may not be given in that setting? Forget whether it was perfect or imperfect, but earlier you said there can be no clarification. Here, can there be clarification when the defendant affirmatively seems to be asking for it?
In other words, if I were to say that, if I were to assume that the first statement, should I not have a lawyer in here with me, was not made, and we just went to that second question?
Assume we were to regard that, and just assume, I mean that, as a request for opinion from the detectives that they should not give. So now the dialogue goes on, and he seems to be asking for clarification about his rights.
I think that if we got to that point, then you would be expecting clarification to be given at that point.
So then does the question become whether or not the clarification was accurate, not misleading?
Absolutely. Absolutely. That would be the second, if I were not to prevail on my initial argument.
One of the problems with the rights, and there's a problem with the rights that are read and the reality that exists. So, I mean, Alston's question made a whole lot of sense when you look at warning number 4. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning, if you wish one. I mean, so Alston says, sir, if I did not want a lawyer in there with, if I did want a lawyer in here with me, how would I be able to get one in here with me? It's a very simple, logical question. But we know, those of us in the system, that there isn't going to be an attorney brought in for to assist him or to represent him in the questioning.
Yes.
If he just makes a suggestion of counsel, then there's police officer supposed to stop. But should he be telling him? This is one of the questions I raised in my mind. Should the police officer be telling him that if you're requesting this, I'm going to stop? Or should he just be repeating the warnings? Go ahead.
Justice Altman, I do believe that's a question that this court will eventually have to reach. I don't know whether you're going to reach it in this case or not, but should you reach it in this case, then you're absolutely correct. What the defendant's being told and the realities of the situation are two different things. At minimum, when the defendant seeks clarification, at minimum, he needs to be reapprised of all of his rights, and that is not just half. If he then goes to ask additional questions from that point on, then this court is going to have to fashion.
It's a problem with the warning, because the warnings don't say that if you request counsel, we're going to stop questioning. It's suggesting that if you request counsel, we're going to give you counsel before questioning.
Absolutely.
Correct?
And when the defendant is told, well, if you request counsel, then we're going to stop questioning, it almost seems as if it would be a punishment. But I don't think we need to reach that issue here. But I do agree that this court is going to have to eventually reach that issue. And it is a difficult issue.
Can you focus on the precise words that are used in response? The first sentence, that's on you,
Yes.
is arguably misleading, and you've laid that out for us.
Yes.
Is there anything inaccurate about the second sentence? If you want a lawyer, then we stop, and you're going to get your lawyer.
And you going to get your lawyer.
That's the second time. Help me. That's the second time that you've read it differently than the appellate division opinion, which says, and you're going to get your lawyer, which suggests something different than your argument.
I should have, and I noticed that afterwards, I should have made mention in my brief to this court, the findings of Judge Vasquez in his official order, which I hope was attached as thank you, as an exhibit, that says the language that all the parties agree on after, as I said, extensive listening to the tapes. And that agreed upon language is, that's on you. If you want a lawyer, then we stop, and you going to get your lawyer.
Okay.
And then in fairness, it goes on to the other language. That's why he read that clearly to you and your waiver. If you want to stop at this time, then we stop at this time. It's either yes or no, Damo. And then we go into
my question is the second sentence misleading?
Yes. Yes, in the sense that alone, yes. alone, yes, Justice Rabner. Had that second sentence been followed up with a reminder that, as Detective Smith advised you a few moments ago, if you can't afford a lawyer, one will be appointed for you.
But isn't that what he's saying in the third sentence? That's why he read that clearly to you and your waiver. Isn't that exactly what he was trying to do?
But he didn't do it. He didn't do it. In other words, I think, Justice Long, had the question been asked, and I won't repeat it, the question that precedes, and Detective Muhammad said, that's why, whatever, I'm not going to read his language, that's why we just read you your rights and had you sign the waiver. And if they pushed it towards him for him to read again, or if they read it again to him, then I think in fairness, if this court were to get to the point of allowing clarification, then I would have not that good of an argument on that.
So even referencing back to something that just occurred a few moments ago is inadequate. It has to be reread in its entirety, is your position.
Yes, Justice Rabner. And I think I think that it definitely, if you get to clarification, it has to be clear all the way around. But I think also, in fairness, if you listen to what's going on there, you have someone struggling with trying to understand. And to only give him half of the understanding is clearly potentially misleading us.
And if you're right, it's not remedied. It can't be remedied by correct statements, such as, if you want to stop at this time, then we stop at this time.
Right. Right, because given what he's been, all these ideas floating in his mind, if his idea is, I'd like to have an attorney in here with me, right, this is what I need, and now they say you want an attorney, now he's, again, this custodial interrogation, so these people have the power, and he's going, no, and he's kind of pleading with them. And at that point, he asks, if I want an attorney, how do I go about getting one in here with me? Well, at that point in time, you can't just advise him of half of what he's entitled to.
And in response to the colloquy about whether this is purely a legal issue, no holding based on a listening of the tapes about the intonation, how something was said, emphasis or the like. It's purely a legal question based upon the pure words.
Yes, if we are to adhere to Reed, and we are to say that an ambiguous request, if we were to treat it that way, if this court were to treat it that way.
If we do treat it that way, then we must disregard that portion of the transcript that you read concerning the confusion that even one of the officers may have had, and we should be listening to the tape ourselves and deciding the issue as a matter of law, correct?
I missed that. I apologize, Justice Alden.
Okay. Earlier, you were quoting from a transcript.
From Detective Smith's transcript?
Yeah.
Yes.
I mean, if this is a de novo issue, right, that is a matter of law,
yes,
that we can listen to the tape and decide for ourselves, then we should not be relying upon what Detective Smith said either, correct?
Absolutely correct, Justice Alden, but I think it's very instructive to this court to realize that, let me say it this way, I think that this court would be wise to adhere to the principles of Reed, which says let's not get involved in nitpicking on whether it's clear, ambiguous, how ambiguous, because we're going to fall into a trap. And that trap is many of the people here are going to have different opinions, as did Judge Vasquez, as did Detective Smith, as does the prosecutor, as do I, as to the intonation and what was being asked. And it's better to treat that, if you say it's ambiguous, better to treat that ambiguous request for counsel as a request for counsel, and everything stops. It stops. And there is no harm.
I don't know if it's better. It's easier.
Well, there's no harm to it, Justice Rivera-Soto, because the following, you would imagine a situation where the defendant didn't want to stop the questioning, or didn't want an attorney. But what he said gave rise to an ambiguous request for an attorney. And the officer said, we're going to stop the questioning right now. and as he's either being let out of the room or whatever, he says, I want to talk to you. Or why are we stopping the questioning? Or does anything to initiate without any questions being asked of him, to initiate further dialogue with the police, then that's okay under Edwards and all the federal precedent and all of this court's precedent. So there really isn't a harm here. The only harm is when you treat this, should I not have a lawyer in here with me, as different from saying, I want a lawyer in here with me. And if you treat it differently, then those questions that are going to follow up, because I think we can all agree, we won't use Mr. Alston, if a defendant said, I want a lawyer in here with me, and the police say, you want a lawyer in here with you? That defendant could easily say, well, no, I'm just asking, and then we go right into this. So we shouldn't treat it differently. And I'm sorry.
And your argument is premised exclusively on New Jersey law, common law, case law,
Absolutely.
Evidence rule, and you would concede that in light of Davis there's no federal constitutional issue?
Absolutely. I absolutely would see that. And I do just, if I could, make comment on one of the cases that was addressed by the prosecutor and the attorney general that I neglected to address in my brief, but I think I would like to comment on. Maybe I did address in my brief, but State versus Messina, which is the appellate division case. I think that case is interesting because there the defendant has been interrogated for a while by two detectives. They take a break. He goes out and, I don't know where out, but goes out to smoke a cigarette with a different detective. And during that cigarette break, he says to that detective, do you think I should have a lawyer? Or something along those lines. Now, in that case, the court said that's not an ambiguous request for counsel. He's just asking a question. But they went on to say if it had been an ambiguous request for counseling, everything would have had to have stopped. And no additional questions could have been asked absent the defendant re-engaging the police. So I think that, and I acknowledged at the beginning the Chu case, troubled me with that. And Chu didn't really have to reach that issue because the detectives didn't do that, but they seem to invite clarification. Whereas Reed, clearly, if we view it the same as a clear request, we should end it there.
Thank you, Mr.
Thank you very much.
Ms. Sims?
Good morning, Your Honors. The State did reserve time for a preliminary statement and would like to make that statement at this time.
Please go ahead.
The record in this case shows that the 29-year-old defendant, who has had previous experiences with the criminal justice system, was properly advised of his Miranda rights. Specifically, the defendant was told, 1, you have the right to remain silent. 2, anything you say can be used against you in a court of law. 3, you have the right to talk to a lawyer and to have him present with you while you are being questioned. 4, if you cannot afford to hire a lawyer, one will be appointed to represent you prior to any questioning if you wish. And 5, you have the right to stop answering questions or giving a statement anytime you wish and do not have to give a reason. You also have the right to demand a lawyer during the giving of a statement or the answering of questions and may stop until he arrives. If you cannot afford a lawyer, one will be appointed to represent you. Defendant 5 times acknowledged his understanding of these rights. He initialed his acknowledgement of each right, and he replied no when asked if he had any questions. Defendant next executed a waiver of these rights. The waiver specifically informed defendant, quote, I have been advised and I have read the statement of my rights shown above. I understand what my rights are. I am willing to answer questions and make a statement. I do not want a lawyer at this time, but I understand that I may have one at any time I so desire. I also understand that I may stop answering questions at any time. I understand and know what I am doing. No promises or threats have been made to me, and no pressure of any kind has been used against me." End quote. Immediately following this procedure, defendant made only two inquiries. One concerned the wisdom of obtaining a lawyer, and the second concerned the procedure for a station house meeting. In response, the detectives correctly asked narrowly directed questions designed to ascertain whether defendant was asserting his rights. Twice, the detectives explicitly asked defendant if he was requesting counsel. Defendant's query of Muhammad, quote, "Should I not have a lawyer in here with me?" End quote, followed by the detective asking defendant if he wanted a lawyer, and defendant replying, quote, "No, I am asking you guys, man," end quote, was not a request for counsel. Defendant said two things in this response. One, no, he did not want a lawyer, and two, he was asking for or soliciting the officer's opinion and advice. Defendant's next statement to Muhammad was, quote, "Sir, if I did want a lawyer in here with me, how would I be able to get one in here with me?" End quote. The detective responded, "That's on you. If you want a lawyer, then we stop and you're going to get your lawyer." That's why he, meaning Smith, read that clearly to you and your waiver. If you want to stop at this time, then we stop at this time. It's either yes or no, Damu, end quote. The detective never suggested that defendant would not get a court-appointed lawyer. Placing the detective's response in context, as opposed to dealing with them in isolation, as the motion court did, it is evident that Muhammad, responding to the specific inquiry about bringing a lawyer into the interrogation room, correctly told defendant the choice was his, that's on you. And if defendant wanted a lawyer, questioning would stop and defendant would get his lawyer, not meaning you have to go out and get your lawyer. Miranda excludes any obligation by an investigating officer to provide immediate access to a lawyer. An officer's obligation under Miranda is discharged when he explains that the defendant is entitled to retain counsel and that if the suspect wants a lawyer, all questioning will stop until the suspect has an opportunity to consult with a lawyer. Muhammad was never required to explain to defendant how he might go about obtaining a lawyer. It was sufficient that defendant understood that if he preferred to deal with the police through counsel, questioning would stop and that he would have the opportunity to consult with appointed counsel at some future point. The record also shows that defendant did understand that he would ultimately have access to a lawyer because after his inquiry about retaining counsel and Muhammad's response, defendant told Muhammad that he was satisfied to meet with a lawyer, quote, "when I get to court, I guess," end quote. Certainly, from the questions and answers noted, defendant understood that he would have an opportunity to consult with counsel when he went to court. Further, to the extent that defendant's question about how he would get a lawyer into the interview room if he wanted one could be interpreted as an ambiguous request for counsel, the police followed the correct procedure in ascertaining the defendant's intent. Muhammad asked defendant if he was requesting counsel. Quote, "If you want to stop at this time, then we stop at this time."
But what about the first sentence, which is more troublesome? That's on you. That's either inartful or worse, possibly misleading. How do you respond to that?
Well, first we have to go back to the defendant's question that was asked, which caused Muhammad to respond the way he did. The defendant said, "Sir, if I did want a lawyer in here with me," and I would suggest to the court the fact that the defendant said, "If I did want a lawyer in here with me," means the defendant understands that he has the right to a lawyer. So he said, "Sir, if I did want a lawyer in here with me, how would I be able to get one in here with me?" And Muhammad's response, "That's on you," the state submits, meant that Muhammad was saying to the defendant, the decision is yours, the choice is yours. But I do understand the court's concern, and even Judge Vasquez's statement, that there could be, and even the counsel's suggestion that this is subject to many interpretations. But this is a case, Your Honor, where context matters. Here, after saying "that's on you," meaning the decision is yours, the officer actually went on and said, "If you want a lawyer, then we stop, and you're going to get your lawyer." That's why he read that clearly to you and your waiver. If you want to stop at this time, then we stop at this time. It's either yes or no, Damu. The state submits to Your Honor and to this court that reading that entire response, as opposed to just one portion of the response, when taken in context, this officer was telling the defendant that you do have the right to a lawyer, and we will stop if you are pretty much invoking that right to counsel.
But what it still leaves hanging in a cloud of ambiguity is whether or not he's got to get a lawyer or whether or not the state is going to get one for him. If you take the words "you going to get your lawyer," what does that mean? You have to? Because a reconstruction is not a possessive apostrophe R-E. So that's another potential ambiguity in that.
If read in isolation, if read in a vacuum. But let's remember, Your Honor, that this exchange between Alston and Muhammad came right after the defendant was correctly and clearly and without any error advised of those rights.
Let's take that, because one of the things he's advised of is that at any point you can assert your right to counsel and remain silent. And one of the first things he says, "I feel like I'm signing my life away." And what is the response by Detective Muhammad? It's not, "No, you have a right to remain silent. You have a right to an attorney." Now he says, "Not signing your life away."
In direct response to the defendant making the statement.
Well, is that an appropriate response? Because one arguably can say that to continue speaking, knowing that you have a right against self-incrimination, your right to counsel, is a really foolhardy thing to do, and maybe it is signing your life away. But the detective here is saying, you're not signing your life away, which would seem to be an encouragement for him to go on speaking.
It may be interpreted that way, Your Honor, and maybe in hindsight, the officer probably should not have responded the way he did to that particular statement, but it was not an invocation of the right to counsel, which is the state submits is the narrow issue that we're dealing with this morning.
Well, there's also the question of whether or not the defendant was being misled after he was given, as you noted, his clear rights. He's now being given misleading statements that are undermining what was earlier read to him.
No, Your Honor, the state disagrees that this particular response by the officer was undermining what was based on where this question, the statements were made, came immediately after the proper administration of the rights. Because again, as you continue through the exchange between the officer and the defendant, I would submit to this court that there are no misleading statements which follow, and that's, of course, is the state's...
Well, let's go to the end, something that I'm a little troubled by. Alston says, I'm already waist deep, about to drown. Why? And Detective Muhammad says, you've got to answer yes or no. And Alston says, I already did, whatever that already did. And then Detective Muhammad says, do you want a lawyer? No. That's what you're saying? And then Alston says, when I go to court, I guess.
Okay.
And was Detective Muhammad's comment, do you want a lawyer? No. That's what you're saying. Suggesting to Alston, who already is going back and forth in his mind, that he shouldn't be asserting his right to counsel. Is it sort of a leading answer to the question?
No, Your Honor, and I say this respectfully. First of all, let's go back to the first part of that question, where you said, the defendant said, I'm already waist deep, why? And Muhammad saying, huh? And then the defendant repeating pretty much, I'm already waist deep, about to drown, why? This was the state submits, this was the defendant's recognition of his predicament, that he already had waived his right, and by following up and by saying I'm already waist deep, he understands he's already in trouble. But to continue with that, Detective Muhammad follows up with, you've got to answer yes or no. Here the detective was trying to redirect the defendant's attention on the issue of whether or not he's invoking his right to counsel. Because let's understand, the defendant still, after he had already waived, and it's now Muhammad's interpretation that the defendant already waived and needed some clarification, probably based on the questions that the defendant asked. Muhammad is trying to direct the defendant back to the issue of whether or not he wants a lawyer, whether or not he's going to invoke that right to counsel. And when Muhammad says, you've got to answer yes or no, and the defendant said, I already did, followed by Muhammad saying, do you want a lawyer? No, that's what you're saying. The state submits that this response refers back to the original defendant waiving his right to counsel, because the defendant said, I already did. I already waived those rights.
That may be true. That may not be true. I think we're really in the atmosphere of complete supposition, whether or not he's referring back to his previous dialogue. You're saying, go even further back, he's referring to the waiver that he had signed.
Right, based on the whole context of how this exchange happened. And again, context matters, Your Honor.
Well,
context really matters.
Can we take a step back? Mm-hmm. Because context does matter. By the point that he has been informed of his rights, he's been arrested for murder. He's been at the police station for over 2 hours. He's now been informed of his rights. He knows he's been arrested for murder, so he does know that he's about waist deep, using his own words. And the other part that I find particularly troubling that no one mentions is that we're reading this exchange as if it were conducted in the King's English. I don't think that's what they speak in downtown Newark.
You're absolutely right, Your Honor. This is an officer who was in the field, and again, even going back to that part of his response, if you want a lawyer, then we stop, and you're going to get your lawyer. An officer was in the field at the station house, interviewing a defendant, advising a defendant of his rights. That's the way the officer speaks.
Are you finished?
Yes.
Yeah.
You acknowledge that under New Jersey law, the state has the burden of proving admissibility By proof beyond a reasonable doubt.
Yes, I acknowledge
So the
that.
finding had to be proof beyond a reasonable doubt. If this court is having the trouble it is having, and two courts below have had such difficulty, how do you sustain the admissibility of the subsequent statement by proof beyond a reasonable doubt? And to compound the question, why doesn't it make some sense, as long as New Jersey has gone its own way in this area, to have what Justice Rivera Soto calls a prophylactic rule? Forget for the moment when it would come into effect, but it would come into effect at least at the time something was stated here. So I've asked a multiple question. Why don't you start with how this is sustainable given the burden that you have?
We do have a very high burden, Your Honors. The state does acknowledge that. But it is the state's position that not every mention, and this court has said so in its decision, as the appellate division has also, that not every mention of an attorney or lawyer, the word lawyer, means that the suspect is invoking his right to counsel. And when you look at the exchange, the entire exchange, which starting from the giving of the rights right up until the end where Mr. Alston says, sure, why not? Nowhere in here, even though the defendant has had the opportunity to do so, has the defendant said, I want to talk to a lawyer. He asked the officer's opinion.
Should I not have a lawyer in here with me?
Asking for advice, asking for an opinion, soliciting that advice or opinion, but not saying, I want a lawyer.
But that's what leads to my question when you acknowledge that they don't speak, what was it, the King's English in downtown Newark, and some do. The reality is, why should a court start to get involved in what that really means? Is it a question? Is it why shouldn't something like that at some point trigger? I know Sanchez doesn't require it here. I know we don't have station house lawyer law. But at some point, doesn't this dialogue give rise to the need to stop? Now, I know your answer is going to be no, but I'm having trouble why it shouldn't.
Because in situations like this, Your Honor, where there may be an ambiguity, the officers are always told, follow up, clarify, ask those questions that are going to ascertain the defendant's intent. And that is exactly, I submit to this court, what Muhammad did. The state's position is that the defendant never invoked his right to counsel, but assuming, based on the exchange between this defendant and Muhammad, that there was some question as to whether or not he, the defendant, was actually making this.
But the next question is, and this is the difficulty with clarifying, shouldn't the clarification have incorporated the Miranda warnings themselves? So he says, should I not have a lawyer in here with me? Shouldn't the response have been, you have a right to a lawyer, and if you can't afford one will be appointed for you. Then it should have been, do you want a lawyer? You have a right. You should have repeated exactly what was in the warnings.
It would have been nice if the officer did that, but the officer was not required to do that because, again, we're talking about a relatively short period of time from the time the warnings were first given to the defendant, the time of the waiver, and then this exchange.
And counsel, if you look at his answer to the question, do you want a lawyer, he's not expressing any doubt about his right. He's asking them for their advice about whether they think it would be a good idea. Because he says, no,
I'm asking you guys, so even if they had said, look, here's your rights all again, and then said, do you want a lawyer, presumably they get the same response. He wasn't saying, I don't understand my rights, I don't know what's going on here. He says, give me advice.
Which the officers are not permitted to do.
You've listened to the tape, have you not?
I've listened to the tape.
Can you tell me, because inflection will mean everything. You want a lawyer? You want a lawyer? How was it? Tell me. Tell me what inflection we want a lawyer.
It was not that second inflection. It was not that second inflection. Quite frankly, Your Honor, if my memory serves me correctly, it was just said very, can I say bland? It wasn't, there wasn't an emphasis one way or the other. It was just a, do you want a lawyer?
Is there anything else you'd like to present?
Your Honor, just to say that in this particular case, this detective, again, did, quite frankly, everything we would hope law enforcement would do. You ask the defendant, you advise the defendant of his right. If he waives, and then there's a conversation between the officer and the defendant. If the defendant does not invoke his right to counsel, or if the defendant makes statements that could be an invocation or is ambiguous, then the officer does have a duty to ask clarifying questions, and the state would submit that that's exactly what Muhammad did in this case. Thank you, Your Honors.
Thank you. Mr. Bornstein.
Thank you, Your Honors. The Attorney General agrees with the State and the Appellate Division that the defendant did not assert his right to counsel before giving his taped statement to the police. He simply asked the detectives whether they thought he should get an attorney, and he also inquired about the procedure in the event he was to request counsel. But the defendant never indicated that he wanted to change his mind and retract his previously executed waiver of rights. Just the opposite. He indicated that he wanted to continue answering the detective's questions and did not want an attorney until he went to court. Even if we assume that the defendant's questions constituted equivocal assertions of the right to counsel, the police fully and faithfully discharged their duty to clarify the defendant's intent before proceeding with substantive questioning.
You think it was when he said not signing your life away, that was a clarification? Or was that the police officer putting his finger on the scale, moving the defendant towards talking?
Not at all, Your Honor. If we listen to the statement, we consider everything that the detectives said and how they were said, these detectives were not strong-arming this defendant. They were not moving him towards any particular response.
Do you think that was an appropriate response to the question, I feel like I'm signing my life away?
Yes.
You think that is not signing your life away? So you have no problem with that?
I have no problem with that. Your Honor, if we listen to the statement, first of all, that response is said very, very softly. If the court listens to the tape, you'll have a hard time hearing that part, not signing your life away.
So softly, Mr. Bornstein, that when the transcriber first transcribed it, she didn't put it down.
Right. It's said very softly, and I think the detective was just responding to what the defendant said. He said, I feel like I'm signing my life away. This was a perfect response. What is he supposed to say? Is he supposed to say, yeah, you're signing your life away?
No, he's supposed to. It sounds, if he were outside of a Miranda setting, it would sound like an obvious response. But when you're dealing with whether or not a person is appropriately understanding and waiving his rights, the answer I would think should have been, I want to remind you of what I just told you. You have a right to remain silent, and you have a right to an attorney. You're not signing your life away. When in fact, if he confesses to a crime, he might in fact be signing his life away. How much time is this guy doing right now?
None.
Well, he has not been tried or convicted yet, Your Honor.
I'm sorry.
He's facing possible murder charges.
Okay, so how much time would he be facing if he were convicted of murder?
Well, that's 30 years to life, Your Honor.
Okay. Well,
But let's not forget, not 2 minutes before, Detective Smith advised the defendant that he had a right to remain silent, that he had a right to an attorney, that he had a right to an attorney during questioning, that if he could not afford an attorney would be appointed to represent him, free of charge, that he had a right to stop questioning at any time, that he had a right to ask for a lawyer at any time, and that if he could not afford an attorney would be appointed to represent him, and that he did not even have to give a reason why he was asserting his right to remain silent or his right to an attorney. The detectives had just finished reading him those rights not 2 minutes before, and defendant had indicated 5 times that he understood those rights. And then the detectives had just asked him, do you have any questions about the rights? He responded, no, he didn't have any questions about the rights. And then they proceeded with the Miranda waiver form, and he acknowledged by initialing and signing the Miranda waiver form that he had been advised of all his rights, that he had read all his rights, that he understood all his rights, that he was willing to answer questions and make a statement, and that he did not want a lawyer at this time, but understood that he could have a lawyer at any time if he so desired. That had just been read to him.
So what? I mean, because he has a right to invoke his right to counsel even after doing that at any point. If he had, despite all of those warnings, if he said, I think I'd like to remain silent, that would be the end of it. If he said, I think I'd like an attorney, that would be the end of it.
Which is why the officer said, you're not signing your life away. Because this was not irrevocable.
Right.
He was explaining to him that in conformity with the rights that had been read and what he had signed, that at any point everything could stop.
True. And it's also significant to point out, Your Honor, that right after this, what's the next thing that Detective Muhammad says? You want a lawyer? That's the very next thing that he said to Mr. Alston after saying, you're not signing your life away. The very next thing he says to him is, you want a lawyer. And as counsel pointed out, it was said in a very neutral fashion. You want a lawyer? If the defendant had said at that time, yes, I want a lawyer, all questioning would have ceased. And he knew, again, Mr. Alston knew at that time that he not only had a right to an attorney, but he also knew that if he couldn't afford one would be appointed to represent him. Detective Muhammad asks, you want a lawyer? The defendant responds, no. He says, I'm just simply asking you guys.
Yeah, but if that were the end of it, he wouldn't have asked the next question. Sir, if I did want a lawyer in here with me, how would I be able to get one in here with me? So it's obviously an issue that seems to be troubling the defendant. Otherwise, he wouldn't have continued with the dialogue. Don't you agree?
Your Honor, he's simply asking a procedural question. He's asking about the procedure in the event he were to request counsel. I think it's very significant.
He's just having a hypothetical dialogue?
Exactly. It's a hypothetical, Your Honor.
Okay.
It's significant that Mr. Alston says, sir, if I did want a lawyer in here with me, how would I be able to get one in here with me? This is almost identical to the question that was asked in State v. Lizanne. In Lizanne, the defendant asked, now, how does it work if I wanted to have an attorney here? Almost an identical question. And it was almost an identical response in Lizanne. The detective says, we will pretty much stop the questioning at that time. Now, the court in Lizanne said that that was not an equivocal request for counsel, and that Lizanne asked no further questions and made no other statement that could be interpreted as an attempt to request counsel. This court recently denied Lizanne's petition for certification. We submit that under that law, there was no assertion of the right to counsel here. At best, there was a hypothetical procedural question directed to the procedure that would apply if the defendant asserted his right to counsel.
How about the standard of proof, which was referenced by Judge Stern? Even if we think you have the better argument, and we could go along with your argument by preponderance of the evidence, here you have to carry the standard beyond a reasonable doubt. That is a very high standard. And you're submitting there's no reasonable doubt within this dialogue, that no reasonable person could differ with your presentation?
Yes, Your Honor, that is what I'm saying.
Therefore, we have three unreasonable appellate division judges.
Well, the appellate division ruled in our favor.
I'm sorry.
And they were very reasonable, according to Mr. Bornstein.
They may not have reached the right result, but they're always reasonable.
Can we dissent to that?
Your Honor, we rely heavily on the decisional law from State v. Messino, State v. Lizanne. The question here is, first of all, did the defendant assert his right to counsel? And if he did not do so clearly and unambiguously, did he do so equivocally? I think even the defense acknowledges that this was not a clear and unambiguous assertion of the right to counsel. They acknowledge that under federal law they would have no claim. So the question is, did the defendant make an ambiguous or equivocal assertion of the right to counsel? We submit that the defendant did not. We rely on Messino. We rely on Lizanne. The case law is clear that not every mention of an attorney during custodial interrogation constitutes an equivocal request for an attorney. A true invocation of the right to counsel, whether equivocal or unequivocal, ambiguous or unambiguous, presupposes an articulated desire to avail oneself of an attorney. If a suspect simply asks a question pertaining to his right to counsel without indicating that he actually wants an attorney, the suspect will not be deemed to have made the type of equivocal invocation that requires cessation of questioning or the duty to clarify. The appellate division quoted from a treatise, and that treatise is the Law of Confessions. The court in Lizanne quoted from that same treatise.
Lizanne is an unpublished appellate division decision.
It is unpublished, as is this one, Your Honor.
Right. So why don't we come back to State v. Reed, which set down a very strong principle that the court was interested in following, which is that any equivocal statement that seems to suggest that the defendant is seeking to exercise his right to counsel is supposed to be read indulgently and in favor of the defendant. And we couple the fact that Detective Smith, when asked in cross-examination, certainly conceded that the defendant was asking questions that seemed to suggest he was inquiring about the procedure for getting an attorney. If we really are to interpret the defendant's statements indulgently, as Reed indeed says right out that we are to do, why would we treat a procedural question as anything less than the equivalent of a substantive request for counsel?
It's true that an equivocal request for an attorney has to be interpreted in the light most favorable to the defendant, but the law is also clear that an equivocal assertion of the right to counsel will occur only if the suspect's statements or questions appear to contemplate an invocation, as opposed to simply seeking a better understanding of the rights. It's true that language appears in the case law, Your Honor, but that language is immediately followed by some additional language which is significant. Law enforcement officials are not obliged to accept any words or conduct, no matter how ambiguous, as a conclusive indication that a suspect desires to terminate questions. At best, these are equivocal assertions of the right to counsel. We submit that they're not even equivocal assertions of the right to counsel. They're not assertions of the right to counsel at all. But even if they are equivocal...
A defendant that has the temerity to ask about procedure is hardy enough to ask those kind of questions is being treated worse under your scenario, because you're saying now it's not a good enough request for counsel. That hardly seems like a good rule to apply going forward, and certainly does not seem to be a fair reading of what was going on in the station house.
No, what I'm saying, Your Honor, is that if a defendant makes an equivocal assertion of the right to counsel, and if he makes a statement or asks a question that arguably amounts to an assertion of his Miranda rights, and the interrogating officer recognizes that the statement or the question is susceptible to that construction, then the officer can either cease his questioning or he can ask narrowly tailored clarifying questions designed to understand the defendant's intent. The case law makes clear that the officer can do that. He can't proceed with substantive questioning, but he can ask narrowly tailored questions designed to understand and explore the defendant's intent. That's what the detectives did here. That's all they did. They didn't proceed with substantive questioning until they had asked a series of narrowly tailored questions designed to clarify the defendant's intent. Only when it became 100% crystal clear that the defendant did not intend to invoke his right to counsel, but instead wanted to answer the detective's questions, only then did they proceed with substantive questioning. We submit that the officers in this case demonstrated honorable restraint. Time and time again, this defendant was indicating that, yes, he wanted to speak with the police. No, he did not want to assert his right to counsel. But because of the questions the defendant was asking, because of his initial reluctance, they showed great restraint. They repeatedly asked him whether he wanted to assert his right to counsel, whether he wanted an attorney, or whether he wanted to continue answering their questions. Only when it became 100% crystal clear, only when the defendant responded sure to the question, do you want to continue answering questions, only then did they proceed with the substantive interview. This is exactly how we want our police officers to handle these types of situations. You know, I think in the aftermath of Cook, we now have situations where interviews of suspects that are charged with serious crimes are routinely recorded. They're required to be recorded. And as a consequence, we know exactly, word for word, what is said. We know exactly what the defendant said. We know exactly what the officer said. And by and large, that's a good thing. But the only problem is that when we know exactly what was said, word for word, there's a tendency for some lawyers and some judges to parse through the colloquy, pick apart individual statements, dissect the entire interview process, and review every phrase, every word, every syllable, and every utterance with such hyper-technicality that we can lose sight of the big picture. With all due respect to Judge Vasquez in this case, he lost sight of the big picture. The appellate division's ruling is correct. The appellate division did not take individual phrases, words, syllables, and utterances and read them out of context. The appellate division did what you're supposed to do. They read the entire statement. They considered everything that was said in its proper context, we're asking this court to do the same. When you look at the entire colloquy from beginning to end, there is no doubt that this defendant never asserted his right to counsel, even though he knew his right to counsel and knew that if he wanted an attorney, all he had to do was ask for one, and an attorney would be appointed for him if he couldn't afford one. We submit there was no violation of the defendant's First Amendment rights. We submit that the defendant knowingly, intelligently, and voluntarily waived his rights. We ask this court to affirm the appellate division's reversal of the trial court's suppression of the defendant's statement.
Thank you, Mr. Bornstein.
Thank you.
Mr. Bell?
I would just like to take issue with one point. I agree with the Attorney General when he says that many things are coming before this court after Cook that never came before this court before, and that's because they were never transcribed in those Q&A statements before. Now we do have the benefit of hearing it. And this is the only point I'd like to make, Justice Holmes and everyone. When Detective Smith begins the Miranda process, you can hear it on the tape, and he's going through each right one at a time. Detective Muhammad appears nowhere. Detective Muhammad interjects himself when it looks like Damu Alston may be about to assert his rights, that he is getting hesitant about giving this statement. So, Justice Holmes, with all due respect to this court, and the fact that it's low is even more powerful because you hear it on the tape. You can imagine it as it happens. When he says, I feel like I'm signing my life away, which he says low, Muhammad, that's when he reaches out, not signing your life away. And that's the dynamic at play here. And I agree with Justice Rivera-Soto that we cannot lose sight of the fact that we are looking at these things and reading them as if they come one after another, which they don't. Some are on top of each other. As if a hearer can't hear different things with Justice Rivera-Soto. I'm sure you're alluding to the different transcripts. And even at the Miranda hearing, and I know the court saw this and we didn't pursue it because we listened to it. At the Miranda hearing, the transcriber has Mr. Alston saying, may I have a lawyer in here with me? I mean, that's the hearers. These things are happening in context. And that's my only point. Detective Muhammad wants to get that statement. Detective Muhammad is trying to keep Damu Alston on track to give that statement. He knows what he's saying to him. He knows what he says and what he leaves out. And as Justice Alban even indicated, he even answers the most important question at the end.
Can you tell from the transcript, though, Mr. McMahon, whether Mr. Alston addressed his question to Detective Smith or to Detective Muhammad?
Which question? No. The answer is no.
The point where you say that Detective Muhammad interjected himself in the process. He was clearly already in the room.
Yes.
He was clearly part of two detectives who were going to conduct the questioning. If you read the subsequent questioning, they're tag teaming, so they knew exactly what they were doing. And you want us to infer that somehow Detective Muhammad sort of jumped into the middle of this when it was Detective Smith providing the warnings without being able to tell us? Because I don't think you can, I don't think anybody can, whether Mr. Alston, when he asked that question, turned to Detective Muhammad instead of turning to Detective Smith.
Justice Rivera-Soto, if you believe that there's another interpretation, then I'm sure that you'll apply it. But I think with good common sense, I'm sure Damu Alston, when he says, feel like I'm signing my life away, when he says that, I doubt it's directed to either, but it's Muhammad who jumps in, Muhammad who sees where things are going, and Muhammad directs that portion, and he keeps them on track. That's my only point.
I understand the spin you're placing on Detective Muhammad's speaking up at that point, but in your experience, have you ever seen two officers administer the Miranda warnings, or is it typical that only one does?
Absolutely. I would agree with that, Justice Radner. Absolutely. What I'm saying is I'm just saying, in fairness, when you listen to the tape, and I encourage multiple listenings to the tape, when you listen to that tape, Muhammad jumps in where it's necessary to keep things on track. And my final point, and I'll just say this, I'm not sure, but I would suggest to the court that when Detective Muhammad says, do you want a lawyer? No, that's what you're saying? If he had said, do you want a lawyer? Yes, that's what you're saying? Damu Alston probably would have said yes, because he was very deferential in all his responses to these officers, reflecting what this court recognizes as the vast discrepancy in power between the two sides during this process. Thank you very much.
Thank you, counsel. We'll take the matter under advisement. The next matter,